One promotion.
Previous lordship. Lordship, let this matter maybe pass over for time being, lordship. Much.
Item 2.
Maybe resolution. My lord. Page 23, my lord. Father name Saman Ali Sheikh, my lord. Saman Ali Sheikh, page 34, my lord. Link, my lord. Original is page 35.
34.
Page 35, my lord. Mulukjan, Saman Ali Sheikh, Gudipara, part 6. And headmaster was examined, my lord.
The school headmaster. Headmaster examined.
My lord, page 92, my lord. Page 92, my lord.
Page
92, my lord. And mother also reduced evidence, my lord. Mother also reduced page 74.
You go and cross-examine this week. I think he is not crossed.
Further cross-examination by the
Question
state.
put by the court, my lord. That is.
Firstly, you cross-examine, and secondly, you also verify whether that, what's the name of that person?
Saman Ali Sheikh is the father. my lord.
Whether that Saman Ali of that voters list and this Saman Ali is same or not. Go and verify in the village whether there are one Saman Ali or two Saman Ali.
The village is same, my lord. Part 6, my lord. Part
In
of
the village also there may be persons, two persons.
Yeah,
who
ma'am,
is same
yeah.
there. Let them verify. There, Mr. Richard, I'm going to also got a petition. Put in, it's so helpful. The petitioner Mulukjan Bibi alias Moleka Bibi had been referred to the Foreigners Tribunal number. Where is the order of the
page
tribunal?
99, my lord.
99. I've been referred to the Foreigners Tribunal number 7 Dhubri at Bilasipara for rendering an opinion as to whether she is a person who entered the state of Assam on or after 25/3/1971, resulting in registration of FT 7th Dhubri case number 36/BLP/18. An opinion dated 89/2018 had been rendered declaring the petitioner to be a foreigner. Being aggrieved, this writ petition is instituted. In the writ proceeding, the petitioner relies on the voters list of 1970 of village Gutipara, part 4, police station Dhubri, Bilasipara in the Dhubri district, which contains the name of Saman Ali Sheikh, son of Ahad Ali at serial 31. It is claimed that Saman Ali Sheikh, son of Ahad Ali of the voters list of 1970 is the father of the petitioner. To substantiate the same, the petitioner relies on a school certificate issued by the headmaster of
Page 34.
by the headmaster of the Posuar Khal LP school, which contains the information that Muluk Jan is the daughter of Saman Ali Sheikh of village Gutipara Part 4.
Six.
6. The headmaster of the school had also deposed before the tribunal as DW7, stating that by exhibiting the school register in original and stating that the information that the father of Muluk Jan Bibi is Saman Ali Sheikh of Gutipara village, village Gutipara Part 6 has been derived from the information contained in the school records. It is noticed that the DW7 had not been cross-examined by the state authorities, but for the DW7, not 7, that mother,
Is 74, my lord.
74. Further, Sahela Khatun, wife of Saman Ali Sheikh of village Gutipara Part 6, had also deposed at DW3, stating that Muluk Jan Mallika Bibi alias Muluk Jan Bibi is her own daughter, her own legitimate daughter. Their own daughter. Full stop. It is not DW3 cross-examined. No, it is noted. You notice that DW3 had also not been cross-examined. In the circumstance, matter remanded back to the tribunal to enable the state of Assam to the Home Department to cross-examine DW7 and 3 as regards the veracity of the information contained in their deposition. The state of the Home Department may also make their own verification as to whether Saman Ali Sheikh of the voters list of 1970 of Gutipara Part 6 and Saman Ali Sheikh referred in the school certificate as well as the evidence of DW7 are one and the same person. Upon doing the needful, reason order be passed.
Obligation.
Item 3,
Lordship, in item 3, Lordship had passed orders for the SP to make an inquiry whether Sabitullah and
The report is available.
no.
It stated that
I have some submissions to make. The inspector has visited his place twice. He is not cooperating with the police at all.
Who?
This Habibullah Sheikh, Lordship. And he refused.
by our earlier order of 2/5/2023, the Superintendent of Police Border Dhubri was required to make an inquiry and submit a report before the court whether Sarifullah, father of Habibullah Sheikh of the voters list of 1966, and Sabitullah, who is the father of the petitioner, are the same or two different persons. MSA Burma, Learned Counsel for the Home Department of the Government of Assam, has made a statement that although the Superintendent of Police Border had made an effort and through the inspector,
To the inspector.
through the inspector of schools,
He visited
Dhubri,
his place twice.
yeah, and also visited the house of the petitioner twice, but the petitioner is not cooperating. Petitioner is directed to cooperate with the Superintendent of Police as well as the inspector of schools.
Yes.
List after
List
2
after
weeks.
2 weeks for the report.
Obliged, Lordship.
item 4,
The order to lay the ground.
Lordship, this matter may be taken up after some time.
item 5,
So it's, see if we're going to- Yes, we have framed the question you wanted. Instead of going into all these, why don't you say who is your father? If you can produce relevant material, we'll issue notice and pass an.
Page 18, my lord.
Sorry,
Page 18.
18.
Lord.
66
Serial number.
village Kosaripara.
Lord.
And who is he? Sonaruddin or Manaf?
My lord, serial number 273, my lord.
73. Sonaruddin Mia is the father
Lord.
of Aziz Mia. Which document will show?
My lord. Page 35, my lord. Is the land document we have submitted.
35 land document. Sonaruddin Sheikh.
and serial number 6, my lord.
Son of Osman. The city Aziz Mia, Sulaiman. Yes, notice records. Implementation. Right.
Item six for admission.
The petitioner refers to the voters list of 1966 of village Kosaripara containing the name of Sonaruddin, son of Osman, and has also referred to a Jamabandi which contains the information that the name of Abdul Aziz Niki. Abdul Aziz had been mutated in place of
Aziz Mia,
Sonaruddin.
my lord.
Aziz Mia.
Aziz Mia had been mutated in place of Sonaruddin in respect of a plot of land in village Kosaripara. Give the observation to 3 years. Yes,
Worship, in process of the last order,
uh,
Worship had got in touch with the BARC to get some papers. Worship. In fact, they are in touch with the agriculture department,
hmm.
but it has got some limitations now, Worship, which is annexure 1 to the letter dated 24 April. Worship.
Means it may not work or what?
It may not detect everything. So the limitations are given there, and it detects only 12 insecticides.
That carbaryl, LB-carb, carbofuran, carbosulfan. If they use something else, it may not be detected. At least use it for these 12.
It's color based on the agriculture department.
No, what we feel, suppose this kit, it detects something, it may not be conclusive.
It may
We
not.
understand, it may not be. But still, prima facie don't
Some-
allow that
some
vegetable
detection.
to enter the city,
Yes.
to be marketed in the city. Seize a particular sample from that one. Send it for regular test. And take the name, address and everything of the person from whom it is seized. If the regular test detects that it is some prohibited chemical, take action against them. Go to the source from where these vegetables are coming from, act at the source. I think that can be done
There's a,
because this is a testing in the road itself.
yes.
It's only prima facie. But prima facie indication, don't allow it to enter. Send it back and seize a part of it. Send it for regular test.
And Worship, there was a meeting.
But
held-
are our orders having any effect, or we are just passing orders and things are merrily going on as it is required?
Lordship, here the checking and testing has been done by the Commissioner Drugs and Food Safety, Lordship. He
No,
can-
we require all of you to act.
Yes, Lordship, but the testing part is
Uh-huh.
being done.
We are not looking at the problem from department wise. Although you may be looking from agriculture point, Mr. Bora from the food and civil supplies point, we are looking at it from a problem as a whole.
Yes, Lordship.
It has to be collectively tackled with cooperation from each other. So that's what we want. We are just asking, are our orders having any effect or it is only in paper?
Some effect is there, Lordship. Some effect.
Some
is-
to what extent?
We are initiating action.
Please come forward.
We are initiating action against actually the farmers, origin is the farmers.
Please come forward. No, you are from the Food and Civil Supplies Department.
No, I'm.
We give you the power
Yes,
even to exceed your departmental power if you feel
yes.
that at source something is wrong. We
Yes.
give you the power.
Okay.
Don't worry.
Okay.
You don't have to depend on somebody else.
Yes. Yes,
This
Miller.
interdepartmental communication. You take action.
Independently, I'll be taking action.
You take action. Because I think the jurisdiction of the food and civil supplies can also be extended to the agricultural fields.
Yes.
Because why are the agricultural products made? For the purpose of converting it to food articles down the line.
Yes.
So you can hit at the source also if you want.
We'll give you regulatory samples and take penal action.
Ah,
Miller.
Tell us if you detect something, you are trying to take action, somebody is prohibiting you, tell us.
Yes.
We'll take care of the problem. But we just request a sincere report from your side, that's all.
My lord, a report has been submitted, my lord.
Yeah.
So some vegetables have been detected, my lord, and they are taking actions, my lord.
We are taking
See, once you start detecting and taking action and the message spreads that now there is a possibility of some action being taken, slowly the problem will diminish. But if you don't do anything, they'll also be emboldened.
we are taking action.
Let the court pass order, we'll carry on our own activities. This is what we are trying to prevent. And we need a cooperation of everyone in this. It's good for you, good for us, everyone.
Yes.
Including your family also. Personally, it's good
Yes.
for your family also. Your children are also consuming these poisonous foods. Same is with all of us here. Please cooperate. And it's stated by Mr. R.K.D. Chaudhary, learned DYSGI, that the Bhabha Atomic Research Center, bracket BARC, Mumbai, has certain kits for detection of contaminous substances in the vegetables, but such kits are only such kits would only be in respect of 12 of the items mentioned in the report of the Additional Chief Secretary to the Government of Assam in the report of Dr. Prasoon Kumar Banerjee, Head Nuclear Agriculture and Biotechnology Division. Even if the testing kits would be applicable for 12 of the contaminous elements, still we are review that the same would enable the authorities to progress further in detecting the contaminated vegetables, at least for the purpose of such 12 contaminous substances. Accordingly, we request the Bhabha BARC to carry forward the protocol required to make such testing kits available to the Agriculture Department and the Food and Civil Supplies Department of the Government of Assam for making the end use of such toolkits, testing kits. Sorry, your name, please, Commissioner Food.
Abhijit Borwa, sir.
Mr. Abhijit Borwa, Commissioner of Food and Civil Supplies, who is
Food
personally
safety,
present.
sir.
Sorry,
Food safety.
Food.
Commissioner of Food Safety, sir.
Commissioner of Food and Food Safety to the Government of Assam, who is personally present before the court, has stated that the department is earnestly pursuing of detecting the contaminant substances in the vegetables, but a problem arises that the contamination takes place at the level of at the level where the vegetables are produced in the agricultural fields. We request the Commission Secretary to extend the jurisdiction of the Food Safety Department to also undertake their activities in the agricultural fields if necessary to detect the contaminated vegetables and take appropriate action. We also request the Agriculture Department to cooperate with the effort in as much as it is a necessity in the public interest to eradicate the availability of contaminated vegetables in the market, which, as per the reports we have already obtained, seriously affects the health of the citizens. If the two departments face any difficulty, insurmountable difficulty to carry out their activities, the same may be brought to the notice of the court. List again on so and so for further consideration, and in the meantime, the actual actions that may have been taken at the ground level till the next returnable date may be produced before the court. So, Mr. Boyce, please list on after 3 weeks. We are listing after 3 weeks.
Yes.
The reports and be kept on record. Reports. It was there. But we don't need. Mr. RKD Chaudhary, that series you want to continue now or after some time? It's up to you.
Then I am preparing a note and further reports.
So you have almost finished. Mr. Majumdar also must have almost finished.
Uh,
You just take his view also. We'll call up when both of you are ready. Or having some other matters today.
Court number one, Lordship, that is a series. I'll wait for some time if he comes, Lordship.
So in the meantime, we'll hear the petitioners for their reply.
Yes.
Close the matter. It's okay. After some time,
Lordship,
after some time. Or
I'll
now.
wait for Mr. Majumdar and
Okay, we will.
Item 13,
Yes.
May I, Your Lordship? Lordship, in this case,
Oh,
Lordship,
bro. About this.
Lordship, in this case, Lordship, the landed tribunal refused to accept the WS in obedience in chief of the petitioner. Lordship, I may be allowed some time, Lordship. What is the reason? Lordship, first, Lordship, the petitioner received notice. Then, Lordship,
No, first tell us what is the grievance? You have submitted WS.
Lordship.
No,
Something is
we,
different, Lordship, in this case, Lordship. Petitioner received notice.
Mr.
appeared-
Majumdar, we'd like to hear you in one line. What is the difference? So that we can also start thinking in your terms.
Lordship,
You just can't go on taking us everywhere you want to take us and then say this is what it was.
what happened?
Tell us what is your, formulate your point, what you want to argue in one line, and then start arguing.
Lordship, actually, the entire Lordship initiation of the proceeding is itself
Initiation of the proceeding is
Lordship,
wrong.
the reference, Lordship, there are two references. First reference, Lordship, petitioner received notice. She appeared, submitted WS evidence, and she also crossed. At the time of argument, it is revealed that, Lordship, from the record, Lordship, page 40, that the reference is in her favor, Lordship, page 40.
Page 40.
And the vernacular is page 42, Lordship.
Form of reference.
Yes, Lordship. Here, Lordship,
Where is
page
it?
41, Lordship, page 41, column 11, grounds for having reasonable
This is the
doubt.
same question we put to the Learned Council the other day. Does the,
The subject had produced valid voter list of 1965 in the name of her father.
so how did the superintendent came to know that that person is her father? Did he make any inquiry?
Lordship, at that time.
Suppose X goes and produces one voters list saying that this is my father.
Yes,
The superintendent will accept it or he will make a further inquiry whether that X is actually the father or not. Suppose tomorrow I can take the voters list of your father also, produce it before the superintendent, say that this is my father. Who will decide it? Because these things are going on. These fraudulent practices are going on in the tribunal also. How the superintendent is to accept it?
a detailed inquiry is required, Lordship.
So he has referred it.
Yes,
So
Then
after the
Lordship-
reference, what happened?
then the tribunal returned back.
We'll ask the tribunal to decide you on merit. That's all. Let the tribunal decide on merit
Lordship,
whether
Tribunal, what happened, page 43,
we are
dispose of this matter.
we are taking care of every what happened.
Yes.
Go to the tribunal, produce
Yes.
whatever material you want to produce,
Yes, yes.
prove your citizenship. That's all.
Lordship, then Lordship, I may be allowed to submit WS evidence in fresh. Lordship.
Everything.
Yes,
You'll be given every opportunity
Lordship.
unless you are trying to
Yes, yes.
overreach the system. You'll be given every opportunity, every document.
Lordship.
Just go and prove your
Yes.
citizenship. I think that is better for
Yes,
you.
it is, it will be.
And why did you approach this court?
Lordship,
In what
Lordship, after that Lordship, tribunal dispose of this Lordship proceeding and refer the matter to again to the Superintendent Police. Page 43,
Page 40,
43, Lord.
43.
Lordship. By this order, refer the matter, Lordship, to the Superintendent Police.
What is this High Court order of WPC that faulty, it should be returned back?
Lordship, I have this order, Lordship. Yeah, Lordship, this matter is not applicable in this case, Lord.
Faulty wale bure hote hain bola jane. See, Mr. Sharma,
My lord.
if your reference is faulty, why should it be sent back to the SP? It doesn't make any sense of any faulty reference, correct reference, etc. Wherever the authorities have any doubt on the citizenship of a person, a reference is levied. And the law requires that the proceeding will appear before the tribunal, discharge the burden under Section 9, prove his citizenship by any material that he may have. And there must not be any restriction on the part of the tribunal in not allowing any opportunity to the proceeding. Give him all the opportunity, allow him to produce everything. Let the tribunal decide whether he is a citizen or not.
Yes,
So if the reference is returned back, don't you think it is against the public interest? So a suspected foreigner will remain without a reference. He'll be enjoying everything. Have you thought about the other consequence? These are not civil court proceedings where everything has to be technically perfect. Yes, Mr. Majumdar, I think we have to take your view in this.
I was.
One order is produced, will show that page 43 order.
And in this judgment, Lordship will find the order page 4, Lordship, page 4. Page 4.
Page 4
Page
is
4,
the paragraph.
Paragraph 20, Lord. The details of this WPC is there. Lord.
Given that para 20 or so. Then read that para 20, that first one. Yes. Details in So it speaks of some faulty reference.
Right.
Let us take a holistic view of the whole thing, a wholesome view. A man is suspected to be a foreigner. Authorities don't have any material of their own to whether he is a foreigner or he is not a foreigner. Para 97 of Muslim Mandal requires that you make an inquiry.
Right.
Okay, you make an inquiry. Now, after making the inquiry, what will the Superintendent of Police Border do? He can neither declare to be a person to be a foreigner, nor he can declare him to be a citizen. He does not have that power. Unless he is so overwhelmingly convinced that this man has proved everything that he is a citizen. So I refuse to make a reference. Suppose somebody refuses to make a reference. What will be the legal consequence? The fact that a citizenship is not determined will remain forever. So he is either a non-citizen or he is a citizen, no one knows.
Right.
And where is the relevance of a faulty reference? These are not civil proceedings that ultimately the entire proceeding will be guided by whatever you have stated in the reference. In a civil court, yes, whatever you state in a plaint, the whole proceeding is guided by those averments made in the plaint. You can neither go beyond the plaint, nor you can go a little less of what is stated in the plaint. But in these proceedings, this reference is not a plaint. It is reference is only a question had arisen in the mind whether a man is a citizen or not, and that requires a determination.
Yes.
Once the proceeding is referred to the tribunal, his issued notice appears, it is his legal right to avail every opportunity to prove that he is a citizen.
Yes.
There is nothing technicality that in the written statement you did not write this. We are not going into this. In the list of witnesses, you did not mention this person. We are not going to into this. In the list of documents to be relied, you did not rely. Now you cannot rely.
Those things are not there.
Where is the relevance of those aspects? Give him the complete opportunity. He will produce every possible
Material.
document that is available to him. He will say that these documents for this reason indicates I am a citizen. And you pass your order.
Yes,
If it is yes, yes. If it is no, you reject it.
absolutely.
Don't you think these things are giving unnecessary complications?
Once this.
Reference is only a procedural requirement. That's all. It is nothing to do with binding the parties
Yes.
in respect of what stand they are going to take, what they are required to do and what they are not required to do. It's
Technicalities should not be given so much of emphasis.
So now he says that there is an order sending back my reference. Suppose the reference is sent back. Don't you think the question whether this man is an Indian citizen or not, or whether he's an illegal migrant, it's undecided?
Undecided.
Firstly, what will be the status of that man henceforth? Number two, what is the public interest of the state henceforth? If you don't determine, you may be allowing an illegal migrant to function as a citizen. You're exposing the country to all the risk. If he is actually a citizen, you are all along throwing a doubt on his citizenship. You are affecting his legal right also. Will you please take up this matter? We'll hear you on some other day.
More or less, the issue is what your lordship has said and what is there. It's clear that unless there's no question of sending back, you have to decide. Because if you send back, what they will do, they will not.
That's what I'm saying.
So far as the.
If actually he is a citizen, a doubt will always remain on citizen and he will be affected. If he is not a citizen, the state will be affected because you are allowing an illegal migrant to function as a citizen. Everybody is equally affected.
In this case, lordship, after sending back, lordship, the superintendent will police without making any inquiry, lordship. Again,
No, this inquiry also, it's nothing mandatory, the para 97.
lordship, again, the.
Para 97 is basically an enabling provision
Yes.
to sort out the matter if possible at the first stage itself. It's nothing mandatory.
Page 46, lordship,
Even
again
is-
required, lordship.
Not made an inquiry, you prove you're a citizen. You have all the material with you.
Yes.
Just go and prove you're a citizen. Or unless you are shying yourself from getting determined because you don't have material with you, trying to take a technical advantage.
No, no. Here, lordship, again send lordship reference. Lordship.
Reference is only to initial people to do, not to bind the parties in any manner. Again, in that last page, first line, authority with disagreement note for making a correct reference. Why do you need a correct reference? If the purpose of the reference is only to initiate a proceeding, why do you need a correct reference? And number two, in Horbananda Sonal, I think first one or the second one, Supreme Court is very specific. Supreme Court says that the authorities do not have any material with them to arrive at a conclusion whether a man is a citizen or not. And this is the reason Supreme Court says Section 9 of the Foreigners Act 1946 is justified to shift the burden on the proceeding, because it is you who have your material to show. You show it. So suppose if the law presumes, as held by the Supreme Court, you don't have any material with you to determine, definitely your reference will be a little off the target at times. Again, looking contradiction with a civil suit, why is the plaintiff given so much of relevance in CPC? Because the plaintiff has all the materials with him, pre-existing material, to make his claim that this is my claim on this material. So the law plaintiff is very strict that if you are not taken, you cannot take it further. But here the situation is slightly different. The authorities don't have. And for the sake of repeating, Supreme Court has accepted that legal position that you don't have the material. If you don't have the material, whatever reference will you make, this is bound to be imperfect in given cases.
This judgment of this 2017 5 GLT 831 has referred to this judgment of WPC 7104 of 2015. Then in para 20, which says, be that as it may, in the facts and circumstances of the case, tribunal ought to have remanded the matter back to the referral authority, that is Superintendent of Police Board on Dhubri, by pointing out the fault in the reference and calling upon the referral authority to make a correct reference. Whether now
No, reference is only one sentence. Whether he is a person who entered the state of Assam from this specified territory on or after 25/3/1971. That's the only reference. There is no other reference. And if you are relying or referring to further materials, that means you have the material with you. Then why do you have Section 9 then? Then you prove it that he is not a citizen.
I don't know whether can it be taken up some other day, because
That's why I say some other day. You please apply.
because my lord, possibly if you what you are saying now may require reconsideration of this judgment, possibly.
It appears so. Then we want to bring down the relevance of this reference. We want to bring down the reference of even the written statement. Because although the expression written statement is used, written statement is a concept from CPC. And in CPC, written statement is a document by which you counter the averments made in the plain. Here is a case, there is no plain. If there is no plain, where is the question of written statement? It is only a stand initially the person likes to take. He can always change that stand also. Tomorrow he may suddenly realize that these matters you see, the man may have materials at home. Suppose today, all of a sudden, somebody asks you to prove your citizenship. Will you remember each and every material that may be at your home? You may not. You may project one or two. Tomorrow you may recollect that, oh no, there was one old ration card of 1960s also. Let me go and take it, that one. How can that be prevented? That in the initial one you did not write about the ration card? No, you are out. Take a more wholesome view, make a correct determination. This is a very serious problem, in fact.
Possibly, because
It's a serious problem. It has to be determined in the most correct way.
otherwise this kind of orders will continue to be passed by the tribunal based on this judgment.
No, not only this, otherwise the whole concept. Find out the foreigners, detect them, declare them, take action.
Reference means what? There is a doubt.
There is a
Now, doubt remains, you ask them to make a fresh reference. That doesn't make any sense, actually. Doubt remains.
So instead of that, allow the proceeding to, yes, please come forward, produce all your documents, whatever you have.
And tribunal.
And we are going to determine it.
It is the ultimately it is the tribunal which will decide. Referral
And
authority will
tribunal,
not
mind you, it's not a civil court.
Yes.
And nor the CPC is exclusively followed because here there is no plaint. Now, in other words, you are converting the reference into a plaint now. And you expect the proceedings to file a written statement against that.
Basically,
Hormone honor to some. Read the song. You know, more copy to me? No, more underline for a copy. Then I give my copy, my own copy. Deciding one. More copy to. At initial at a marriage to more underline for a copy. And everything. Give me the whole set. Not this one, other one. This one didn't have it. Here's a whole. Mr. Bor, from next time, give me the same copy every time. সদায় এটা বেলেগ বেলেগ নিদিব কাৰণ মোৰ মাৰ্কিংটো নাথাকিলে ধৰিব নোৱাৰিম তেখেতে দিব মাৰ্ক কৰি থৈ দিব মোৰ তেখেতটো মাৰ্ক কৰি থৈ দিব don't keep on changing. So para 26 Parvana Sudra.
number one, my lord.
Number one.
Yes.
After he has given evidence on these points, the state authorities can verify the facts and then lead evidence in rebuttal, if necessary. If the state authorities dispute the claim of citizenship by a person and assert that he is a foreigner, it will not only be difficult but almost impossible for them to first lead evidence on the aforesaid points.
Yes.
So this is the basis.
Right.
So if you don't have material, how can you make a correct reference? Nor it is a reference in lieu of a plaint. Please go through it on this point. When do you want?
Next week, and it's not a very big issue otherwise.
Otherwise, no, but requires something. It will cool you. Not to be booked. You won't be bothered. The petitioner raises a claim that the reference was returned back by the tribunal by arriving at a conclusion that the reference made to it is faulty and contrary to the materials on record. And for the purpose refers to a judgment of an order of this court in WPC 7104, so stroke to 2015. In a proceeding in a foreigners tribunal, the relevant provision of law governing the same is Section 9 of the Foreigners Act 1946, which provides that the burden to prove that a person is a citizen would be on the proceedee himself and not on the state. This provision is also in conformity with what the Honorable Supreme Court had provided in para 26 of Harmananda Honwal 1, that the fact as to whether the person is a citizen or not would necessarily be within the personal knowledge of the person concerned and not of the authorities of the state. In such circumstances, the Supreme Court provided that after the person concerned has given evidence on these points, the state authorities can verify the facts and can lead evidence in rebuttal if necessary. It further provided that if the state authorities dispute the claim of citizenship by a person and assert that he is a foreigner, it will not only be difficult but almost impossible for them to first lead evidence on the aforesaid points. In this circumstance, we have to understand that as per the conclusion arrived at by the Honorable Supreme Court in para 26 of Harmananda Honwal, the state authorities, while making a reference, is not expected to have the complete materials with them to substantiate that a person concerned may or may not be a citizen. It is in this circumstance that a reference is required to be made to the tribunal for a determination on the citizenship of a person. If the state authorities, while making a reference, is expected not to have any material with them for arriving at a conclusion on the citizenship of a person, it would again be a situation in conflict that the reference made is a faulty reference and it is contrary to the materials that may be available on record before the tribunal. We requested Mr. D. Mojumdar, Learned Additional Advocate General, to look into the aforesaid inconsistency for further submission. This conference.
In Sarvananda Sonwal 2 also, referring to para 26 of number 1, 2-3 paragraphs there which are also relevant, quite relevant.
Again, same thing is reiterated.
Para 62 of Sarvananda 2.
So what we expect is that I don't know.
Yes.
I make a reference, you please determine.
Yes.
So how can
There is
that,
no technicality about
how
it.
can that be a faulty? That reference that I don't know, how can it be faulty? And how it is expected that the SP will have beforehand all the materials that the person will rely. So when the materials are produced, you return back the reference saying it is faulty because it is in conflict with the materials produced.
Lordship,
Somewhere down the line, some misconception is there, it appears.
once there is a reference means there is a doubt
Doubt.
about the citizenship. Now, there is no specific way of making a reference. There is no question.
See, reference concept you can borrow from the Industrial Tribunals Act.
Yes, section 11.
What do? They write only one line. Whether the dismissal of the workman
Justified or not.
is justified or not. Rest, everything follows from whatever material
All
is produced
evidence,
by,
all
by
materials.
various parties. Here also only one line reference, whether this man is a citizen or not, or at the best, whether he is a person who came from his military on or after this date. That's the only reference you are making.
There should not be any technicality about the terms of reference. Issue is clear.
Issue is only one.
My lord. Next week, Wednesday, my lord, next Wednesday.
Wednesday,
17.
we said, you said. This one, for reconciliation. It is that we do, right? I guess. What do you know? Anji? You go ahead.
In other matter, my lord, I have concluded, Mr. Chaudhary Kaplis, so far as,
Mr. Chori also said almost completed.
yes, my lord,
Some of the.
Just sum up. Okay.
as far as,
the books.
my lord,
When
as
you
far-
want, now or after some time?
The written note, lordship, I will give by day after tomorrow, lordship, along with the census and one book.
and so far as I am concerned, my lordship directed that I should give the list of cases with paragraph that I have brought, my I'll hand over.
Which one?
A list of cases that I have referred.
With paragraph.
With paragraph. I have brought it today itself, right now.
If you do that, it's easy for us to
My lord,
find out.
I have brought it today.
So we'll be hearing the petitioners then for their reply.
Yes,
You were there, no, Madam Ghosh? For the petitioner, you were
Let
there.
petitioners reply first. I'll assist lordship on
Uh,
Monday.
who appears for the petitioner?
Petitioners, there are several lawyers are there.
Where are they? Ask them to remain present. If they are not, we understand that you have nothing to reply.
Yes, lordship, and on my part, I will submit on Monday.
Monday?
Monday, I'll submit the written.
Today is Tuesday. Monday is longer.
Because I'm working on whatever submission is made. So let them, I have to.
No,
add
no,
on
we are
the
conducting a day-to-day hearing. It can't be that we defer by 1 week.
written. I'll try to then submit by Friday. I'll try my best to.
No, no, today.
Today, let them sum up first.
They are already summed up. That's why I say we have concluded. They are only giving a written note on what they were saying. Those judgments, paragraph number. That we have already taken note of. They are not adding anything to what they have said.
I may take the matter in forward.
I'll take little time because the written submission I want to file. So I'll take little time to.
Day after tomorrow.
Yeah.
Day after tomorrow, we conclude, we pass our order. We can't allow it's almost a month now, we are hearing the same thing.
And petitioner advocate, if they have to submit their.
Yes, others also, if you want, come forward. We are ready to hear you today, tomorrow. Day after tomorrow, we are bringing an end.
Yes,
Whether oral submission or written submission, whichever
Yes.
one you want to give.
yes.
Mhm. खाली लगे नहीं तो दूसरा खाली लगे तो अभी जिस तरह बहुत के तरह से but of course we are listing it tomorrow also. Ask the land council of petitioners
Yes,
whatever they want to submit, let them submit,
yes,
and also day after tomorrow, but
yes,
thereafter no more.
yes.
Well, we have already heard enough. And you have only to reiterate what you have to say, or you want to submit something in addition to what you have earlier submitted.
Yes, lordship. little bit.
Something in addition.
Addition. We want to submit.
Prepare yourself, we'll hear you.
Yes, lordship.
Yes.
Item 14,
May I please, your lordship. My lord, page 26. Page 26. It here's the grandfather and grandmother's name, lordship. Total list of 1966.
Who is he? Asmatullah.
Asmatullah Sheikh and Sorful Bibi,
Is he grandfather?
grandfather and grandmother.
Okay.
My lord, the grandfather's name appears
Hmm.
along with her father at
Page
page,
number?
page 31, lordship.
Page number
The
31.
list of 1979. Sorful Bibi, Juran Ali.
Okay, Sorful and they are together.
Yes, Juran
Father.
Ali is the father.
GM. This is of year 1979.
70.
Now, where is the Durand and the petitioner?
Kabin Nama lordship at page 36.
Page 36. Jorina Khatun.
Tribunal held that the Qazi was not examined, lordship.
Go and examine the Qazi.
Yes, lordship.
Yes, Mr. Chairman.
Yes, lord.
Heard Mr. M.I. Hussain, the counsel for the petitioner, also heard. Jorina Khatun, alias Jorina. What is CMD? Jorina Khatun had been referred to the Foreigners Tribunal number.
Yes, 73.
Where is the order of the
Yes,
tribunal?
73.
Page
73. 73, lordship.
had been referred to the
Six goes for.
Foreigners Tribunal number 6, Gwalpara, for rendering an opinion as to whether she is the person who entered the state of Assam on or after 25/3/1971, resulting in registration of FT case number. Is that nine? Case number FT bracket 61088/GFT/19. Tribunal render opinion dated 31/3/2020 declaring the petitioner to be a foreigner being aggrieved district petition is instituted. The petitioner relies on the voters list or 1966 of his Toranga Jor police station, South Salmara in the South Salmara Mankachar district, present in the Mankachar district, which contains the name of Asmatullah Sheikh, son of Binod at serial 215 and that of Sarful Bibi, wife of Asmatullah at serial 216, where both are shown to be residing in the same house number 88. The petitioner thereupon relies on the voters list of 1979 of village Torangajor, which contains the name of Sarful Bibi, wife of Azmat Ali at serial 212 and that of Zuran Ali, son of Azmat Ali at serial 213. It is claimed that Zuran Ali is the father of the petitioner, and by showing that the name of Juran Ali and Sarful Bibi appears together in the same voters list, where the name of Sarful Bibi also appears in the voters list of 1966 of village Tarangajar. It is stated that the citizenship of Juran Ali can also be determined. Petitioner thereupon relies on the Kabindnama in respect of the marriage Kabindnama, which contains the information that Jaruna Khatun is the daughter of Juran Ali of village. Where is the name of the village?
Page 37, Tarangajar.
Where is Tarangajar?
Page 30.
No, where is Tarangajar written in the
At present,
vernacular?
Tarangajar.
Hmm.
Page 37, lordship. Next.
No, 37 is your English. In
Second
the
line, yes,
Tarangajar. Same. Of village Tarangajar. But it is stated that the Kazi of who had issued the Kabinama had not been examined in the first remanded back to the tribunal to enable the petitioner to examine the Kazi in respect of the Kabinama of the marriage by producing the original marriage register, etc. The respondents in the meantime may also make their verification as to whether Juram Ali referred in the Kabinama and Joran Ali of the 1979 voters list of village Tarangajor are one and the same person. Upon doing the needful to possibly order.
Any further evidence if he
Petitioner may also adduce any further evidence if so advised.
highly obliged. Lordship.
Item 15 for orders.
Hello.
May I please?
May I please, your Lordship? Lordship, the conducting council is on lakhs, Lordship.
Who is he?
Anjan Kalida.
So what is to be done? Time being.
Yes, Lord.
16 for hearing.
Lordship, kindly pass over the matter for time being. My senior is not.
Yes, Mr. Sigdar.
My lord. This case, my lord, admittedly, my lord, the father do not have voter list of 1966.
70 also no.
No, my lord.
Any document?
My lord, yes, that is there, my lord. Lordship may kindly have a look at page 27, 28.
27.
Their original place.
Certified that the petitioner's own cultivated homestead land or village, many Simla, Moja, Rupsi was eroded in the petitioner. Simudin is the father.
My lord, Samudin is the father, my lord. They are rehabilitated during 1771, my lord. There is another documents in support of this, my lord. There is a notice of rehabilitation, my lord. Page 57, my lord. Page 57 and 58. They were noticed regarding my lord rehabilitation loan 300 in the year 69-90 for
Education loan.
yes, my lord. They are rehabilitated and they sought loan,
Where is it?
my lord.
Education loan, where is it?
So these two documents says that
Where is the education loan?
no, my lord, this is not education loan, my lord, rehabilitation loan. Page 57, my lord.
What is this page 30?
30, my lord.
The
These are my
revenue
earners.
paying receipt.
These, my lord, these are revenue paying receipt, my lord. Revenue paying,
Presently, where is Simudin residing?
my lord, Saimuddin, my lord, they're originally Many Shimla, then subsequently they have shifted to village Gugubari. 77 voter list is also there, my lord.
No,
That
no. 77 Ghungubari.
My lord.
Then what is page 29? It's a English translation of page 30. What?
My lord.
Page 30 is some land revenue receipt or something.
Yes,
like
my
that.
lord.
What is that?
This is also
Where is the original? From that photocopy, you
Original-
cannot read anything.
maybe in the record, my lord.
Please check out.
My lord.
Check out what document is that? Maybe it will be of your favor.
My lord.
Next one, yes. We take up the next matter, you just take up.
My
Because-
lord, next is also my case. my lord.
You argue? This one you check up
My lord.
because that's a receipt of sometime of 1970
My lord.
pertains to Ghunguru village.
My
Not,
lord.
not,
Ghungubari.
not the original Municipal
Yes.
village.
Well, because of their erosion in
Mr.
Many Shimla.
Sigdar, you are so preoccupied with erosion You're failing to read a document which may be in your favor.
my lord.
If this is a receipt of any kind of the year 1970 of village Ghungru, it shows that this man must be in village Ghungru in 1970. If it is yes, then 1979 voters list of Ghungru is in your favor.
My lord. My lord, these revenue paying receipts are also compared with originals. Originals are not
Right, voter listed.
in the record.
Voter listed.
They compare. My lord, these are-
Econ page 30, sorry. Some kind of a-
These are of 70, then my lord 74 and 77 in Gugubari.
Mr. Sigdar, what is page 29? You were given some English translation of something
My lord,
that is dated 2/2/1970.
my lord.
It pertains to village Ghugubari,
Yes, my lord.
your present village.
Yes, my lord.
Find out what is that document. That document may be of great help for you.
My lord. But here, my lord,
Again, you are going elsewhere.
my lord, here, my lord, the compared, the originals are not also there. The original with.
No,
compared with
it
original.
is your English translation at page 70. From where did you get it? We want to see the original of page 29, either in vernacular or in English. Because that is possibly a document which is very much in your favor.
ये मतलब देखिए, हाँ.
That's why I say
Yes,
you
sir.
take your time, go
Yes,
through the records.
Yes, my lord, space here, paste in record it is page 38.
What does it say?
My
Read.
lord,
Read it.
it is my lord, a revenue paying receipt of 2/1/1970.
2/1/1970.
My lord.
Revenue paying receipt to what? For land revenue.
Yes, my lord, of Soimuddin,
Of which village?
of well, village, my lord. That is not, my lord, difficult to understand, my lord.
Then how did you understand before making the English translation and annexing with a repetition?
My lord. Gugubari.
Mhm.
Yes, my lord. Gugubari.
Is it Ghugubari?
Tarik. There is no mention of the village.
Then why did you write Ghugubari in the English translation?
Yes, my lord, in some documents there is mention, my lord.
In some it may be, but this one it may not be. This is the only document in your favor. Others are
Yes,
not.
ma'am.
Others, where it is clear, those are of 1974. That is after 71. It is not of any help to you. But this 1970 document is of help.
Gugubari. Gugubari.
Adjourned of the prayer of Mr. E. S. Sigdal in order to enable the land council to examine from the records the original of the revenue paying of the receipt annexed of the receipt, comma, the English translation of which, comma, is annexed at page 29 of the writ petition, which is shown to be dated 2/2/1970 and pertains to village Ghugubari. This next page. Yes, next one.
My lord.
Item 17.
Sorry for Begum. Who is the father?
Sorry for Begum, my lord, here. The father,
Page 35.
page 35, father's name is here.
Supanuddin is the father or
Sheikh.
grandfather?
Father,
Is the father.
father.
And which document you show? Supanuddin
My
is
lord,
the
linkage document is the Kabinnama, my lord.
page number
Page 45, translated. to
45.
Kabinnama.
But village is different.
Village is
Kanoimara,
different.
Kanoimara and Pakhriguri.
Pakriguri, there is a shifting, madam.
The petitioner may produce any relevant material which may establish that Supunuddin Sheikh had shifted from village Kanoimara Part 2, where his name appears in the voters list of 1966, to village Pakhriguri, which is indicated in the Kabinnama at page 45 of the writ petition. Next week.
18,
Yes, madam.
May I please, the Lordship?
Are you there?
Lordship, in this case, Lordship, party wants to engage another advocate in this case, Lordship.
Why, Mr. Rashid is not good.
I don't know, Lordship, but they want to change their
Mr.
advocate.
Rashid is very competent. Why do you want to engage another advocate?
I don't know, Lordship, but
We may not allow it after 6 years. We appoint an amicus and go ahead.
Lordship,
Oh,
call him,
you are with
Lordship.
Mr. Rashid or you are with somebody else?
Lordship, we are in this case, Lordship.
You are with Mr.
Yes,
Rashid.
yes.
Ask him to argue it.
But Lordship, we called him Lordship, but somebody else not to pick up his call, Lordship. So we were unable, Lordship, to communicate him, Lordship.
Let us dismiss this petition. He'll come back to the court with the
Lordship, we need
appropriate lawyer.
sometime, Lordship, sometime, Lordship. try to
If he
communicate.
dismiss for default, once he comes to know, tomorrow he'll come to the court for restoration with the correct lawyer. Either Mr. Rashid or whosoever it is.
Lordship, sometime may be given, Lordship, 1 week, Lordship, I will try.
It
to
is
communicate.
stated by your name,
MRDB, Lordship,
M.
MRDB.
MRDB Land Council, that Mr. A. Rashid, Land Council, who appears in the petition, could not contact his client and somebody else is picking up the phone. In the circumstance, Mr. Rashid is hesitant to proceed further with the matter. Adjournment is sought for a period of 1 week, granted this next week. In the event appropriate presentation is not made in the writ petition on the next returnable date, appropriate order shall be passed.
Yes, obliged.
Tell your client will dismiss this petition, let them come with the
Yes,
client.
I'll try to-
We are not allowing this after 6 years of this business.
19,
Yes, Mr. Motin,
My lord. Voter list of 1966.
page number,
66, my lord.
page number.
Page 17, 17.
1 Taimuddin,
Tasmuddin.
Tajmuddin,
Tasmuddin.
son of
Amina Khatun, my lord.
Nanuruddin.
Yes. Muniruddin, my lord. Grandfather.
It's Moniruddin, okay.
And
He is the
page,
father.
yes, my lord. Page 19, my lord. Also,
Page-
my lord, Tasmuddin.
Who is the petitioner? Osman. Hmm. The Election Commission to produce the copy of the voters list of 1966 of village
Bhakatgaon.
Phokotgaon. In respect of entry number 562, as to whether the name is Tajmuddin or 462. Whether the name of the person voter is, name of the person is Tajmuddin, son of Moniruddin. Now, which page you are replying? Page 19?
Page 19.
What is 19?
Page 19, Tasmuddin, Moniruddin. Amina Khatun, Tasmuddin. Bhakatgaon.
So this is good enough. Why are you relying on 66 then?
2 voters, my
It is
lord.
also acceptable.
2 voters.
Okay, fine. What is the name of the village? Bhakatgaon.
Bhakatgaon.
Which document will show Osman is the son of Taj?
My lord, one Gaugura certificate, my lord, page 28.
So he knows everything.
Yes, my lord, as per his statement, my lord.
Was he present at the time of birth?
My lord, yes, my lord.
Gahura is present when
Gaugura
the man was born.
66 years, my lord.
Huh?
Gaugura age is 66 years.
Maybe 60. Was he present to witness the birth?
No, I don't.
Now, how did he know? Does he know?
And one, my lord,
Hmm.
petitioners a place of birth, my lord, Bhakot Brahman.
No,
he had
is the
passed away.
Gambura a neighbor or something who had access with his family?
And Gambura,
If
his
yes, please
statement,
tell
my
us,
lord.
we'll examine his evidence.
The
Well,
Gambura is stated everything, my lord.
From where has he stated? From where did he acquire that knowledge?
And he stated his knowledge and my lord, as per voter list of 1966.
So we also have a voter list before us.
Yes, yes.
Can I now go and give evidence elsewhere?
And my lord,
If
one,
Osman is the son of Tasmuddin of village Bhakatgaon, produce any voters list of Tasmuddin and Osman together, any subsequent voters list. The petitioner may produce any subsequent voters list of village Bhakatgaon which may contain the name of Tasmuddin and Osman Ali together, or the wife of Tasmuddin, Amina Khatun and Osman Ali together. List again after reading.
Item 20,
in item 20, my lord,
Sorry.
there is a shifting, my lord, upline, downline, brutally, we have to collect, my lord.
The respondents in the election commission may produce the upward and downward voters list of villages.
Village Balmari and Paraura.
Walmari and
Balmari and Paraura. Paraura, my lord.
Paraura. In a circumstance where shifting took place in the year,
My lord,
is shifting is claimed to have taken place in the year.
It is total list, my lord, it is after 90, my lord. After 90, up to 90, they are in Balmar.
Sometime in the year 1990. Yes, next.
21,
Yes, 21, what is it?
Pass for the matter just for the timing.
Next.
22, item 23,
May I please, your lordship? Page number 46 is the voters list of 1966 of the father, sorry.
Yes, page number 46.
Yes, lordship. Vernacular is page 47. Moezuddin is the father.
Moizuddin Salaf Jalal
Yes,
is the father.
yes,
Village is
And-
Gwalpara Part 2.
yes, lordship.
Yes. Which
And
document
then
will show
70
is the
voters
father?
list. 1970 voters list, page 48, lordship. Moizuddin,
That's okay.
Malobi Nessa, mother, father, mother.
Malobi Nessa is the mother.
Yes, lordship.
And who is the petitioner?
Petitioner is Saleha Khatun,
Saleha
lordship,
Khatun. Which
page 55.
55. Jamabandi.
Yes, lordship. Serial number 8, lordship.
Yes, Mr. Sharma.
Yes, Lordship. Remand, Lordship.
Heard MSD Ghosh and counsel for the petition. I also heard. The petitioner Saleha Khatun had been referred to the foreigners tribunal. Where is the order? Beginning.
Order is at page lordship 15. Annexure 1. Foreigners Tribunal number 2, Bongaigaon.
Referred to foreigners tribunal number 2 Bongaigaon for rendering opinion as to whether she is the person who entered the state of Assam on or after 25/3/1971, resulting in registration of case number BG BNGN stroke FT hyphen 22 stroke APR stroke case number 155 stroke 2016. And opinion dated 6/3/2019 had been rendered by the tribunal declaring the petitioner to be a foreigner, being aggrieved district petition is instituted. In the writ proceeding, the petitioner relies on the voters list of 1966 of village Gwalpara Part 2.
গোৱালপাৰা গাঁৱৰে সৃজন পিছত নামটো চেঞ্জ কৰিব পাৰ্টটো চেঞ্জ কৰিব লাগে ন একেখন গাঁৱৰে গোৱালপাৰা গাঁও
Part 2.
Yes. Circle is Srijan Ram.
Under Sri Jangram Circle in the present Bongaigaon district, which contains the name of Moizuddin Salaf Jalal at serial 269 and that of Malobin Nisa, wife of Moizuddin at serial 270, and both are shown to be residing in the same house number 101. A voters list of 1970 of village Gwalpara Part 2 is also relied, which again contains the same information. Petitioner thereupon relies on a Jamabandi of surveyed village in respect of Gwalpara village Gwalpara Part 4, which contains an order of the circle officer in mutation circle officer dated 14/7/2016 in mutation case 92/2016 in respect of a plot of land of DAG number 401, by which, amongst others, the name of Saleha Khatun, daughter of Moizuddin, had been mutated in place of Moizuddin Sheikh in respect Moizuddin Sheikh. By virtue of the order of mutation, the petitioner claims that she had discharged the burden under Section 9 of the Foreigners Act 1946 that she, being the daughter of Moizuddin Sheikh of village Gwalpara Part 2, is a citizen of India. We have noticed that the voters list of 1966 is in respect of village Gwalpara Part 2, whereas the Jamabandi is in respect of a plot of land in village Gwalpara Part 4. The petitioner may adduce further evidence that the reference to Gwalpara Part 2 and Gwalpara Part 4 is of the same place. The respondents in the Home Department of the Government of Assam may also make their verification as to whether Moizuddin Salaf Jalal of the 1966 voters list of Gwalpara Part 2 and Moizuddin Sheikh referred in the Jamabandi in respect of village Gwalpara Part 4 are one and the same person. The respondents may also make any further verification as may be advised and thereupon submit a report to the court. The petitioner may also adduce any further evidence is advised. Upon doing the needful, a written order be passed.
Small submission, Lordship. Even in 89, Part 2 became Part 4 in 89 voters.
Prove it.
Yes, sir.
Show this document to the tribunal.
Yes, Lordship. If you-
We have only noticed the difference, so we
Yes,
indicated
yes,
it.
Time being item 1.
None appears. Oh, you are there.
Yes, Lordship.
Yes, item 1.
Lordship, 1966 voters list of father and mother and uncle,
Page number.
page number 47.
Bakpara Dinir Alga, Profam Kondo. That's the name of the village.
Yes, Lordship.
Who is the father?
Father is real 88. It should have been Taser Ali. It's written as Oser Ali. But against the name of the mother, Nurjan Bibi, is written as Taser. Nurjan is the mother. Then 70 voters list, Lordship, page 49. Oser Ali, Nurjan Bibi. It's of the same village, Lordship. Then petitioner and his mother, page 50.
Name User Toser. Then now, which document will show that Abu Sama is the son of Osero Toser?
Yes, Lordship, page 51, Lordship.
Page 50.
Nur Jahan Bewa, Abu Sama Sheikh Toser
Nur Jahan
Bewa. Father died.
village, same.
No, not same village, Lordship.
Now, how do you know? The petitioner may produce any,
Lordship, if my learned friend helps me out in
the
this.
upward and downward.
Yes.
The respondents in the election commission may produce the upward and downward voters list of village. Bakpara, Dinir, Alga, Pratham Khondo, part 1, and that of
Santoshpur.
Santoshpur.
And Lordship,
In
there
a
is.
situation where there is a claim of shifting in the year,
Yeah, okay, man. Page 14.
list after 2 weeks. Tell Mr. Ali.
Yes, yes, Doctor.
And thereafter also there is a shifting, Lordship. Jomer Duar part 2.
As well as the upper village Jomer Dua
Jomer Duar.
part 2 be also produced in a situation where there is a claim that there was further shifting.
Yes,
List
Lordship.
after 2.
And that order is annexed in page 84, Lordship.
Was a decision taken?
Yes, Lordship.
Was a decision taken in that order? You read and be satisfied yourself.
Yes, may I read that order?
No, you don't have to read. You read and satisfy yourself whether it was a decision.
My understanding, it's a decision, may not be total proper, but it's a decision.
What is a decision? What is the legal concept of a decision?
Decision
And
based,
by following that legal concept, whatever is provided, is it a decision?
yes. Based on
But
what.
first, you have to tell us what is the legal concept of a decision.
Yes.
We'll
Lordship.
understand it, then examine as to whatever is provided, whether it is a decision or it is not a decision.
Wait, like, because.
Suppose today I write, MS D. Ghosh has relied upon this, a list of documents, list of this thing.
Yes, Lordship.
Accordingly, I declare the person to be an Indian citizen.
Yes, Lordship.
Is it a decision? First, I'll refer to only what you have referred. Next, immediately I'll come. So and so is declared. Is it a decision?
Giving a reasoning. There should be a reasoning to
As
a
to
decision.
which material has led to
Yes.
the conclusion that he is a
Yes,
person, that
Lordship.
is called a decision.
Yes, Lord.
Do you find these provisions in the order you are referring for the purpose of res judicata? Abdul
Yes.
Kudu says res judicata is applicable in these proceedings.
Yes, Lord.
It does not say that whatever was given in the earlier, we were bound by it and no subsequent proceeding. Does it? It doesn't say that. It only says the principle is applicable.
Yes,
So
Lord.
we'll examine what is the principle
Yes, Lord.
and whether that principle is satisfied or not.
Otherwise also he has all the documents.
Then
Migration,
why don't you go to the other one?
yes, he has migration certificate due to religious persecution. His parents and elder sisters, they have
That's
migrated.
okay. Where is the migration certificate?
Migration certificate is at page 67.
67.
His father is Chittaranjan
Just a
Das.
minute, page 67.
Yes, Lordship.
What is this? Chittaranjan Das of village so and so Maiman Singh has requested permission of the government to migrate to India and settle. It's a migration permission. Accordingly, certificate is given to authorize him without a passport through the check post.
Through Coach Bihar, check
Very-
post they have.
Very well, Chittaranjan Das.
Yes, and then
Who is the petitioner?
petitioner is Pukon
Kukon Das.
Pukon Das. And he's
So which document will show Kukon is the son of Chittaranjan?
75 school certificate.
Have you examined the headmaster?
Yes,
Is
Lordship.
Kukon or Pukon?
Pukon,
PH or KH?
Pukon, PH.
PH, Kukon Das.
But he also is known as Kukan. But his name is Fukon.
See, a good gentlemanly character has only one name.
Yes, Lordship.
Moment a person having multiple names, there must be a reason.
Because in village, in the evidence, it has been stated that in
Now
the village,
Milanpur. So how do you know that this Chittaranjan of Milanpur and that Chittaranjan is same?
and Lordship 71 also, but there is a shifting because 71 is of Mongol Doi of the father.
No, let us go
Yes, Lordship.
sequence wise.
Yes,
Chittaranjan Das had migrated as per
this
this
migration.
page 67.
Yes.
It is of 1964.
Yes, Lordship.
Very well. It is not stated where he is residing in Assam. Okay, in Coach Bihar.
Coach Bihar,
He
he
is
is
in Coach
migrated and
And how do you
requested,
know that Chittaranjan of that school certificate of village Milanpur and Chittaranjan of Coach Bihar,
not Coach
person who
Bihar.
migrated,
In
they are
Assam,
same.
if we see through Coach Bihar, they have come, but they have settled request
Madam
for
Ghosh,
permission.
We
Yes.
understand, everything is true.
Yes, Lordship.
But only statements will not do. You have to go a little beyond that.
Obviously, after migration, a person without everything, they were there and thereafter they have shifted to.
Madam Ghosh, if you are lacking the word obviously, he will rely on many other obviously and say
Yes.
just the contrary.
Yes, there is shifting, Lordship, because they have
How do
migrated.
you know that it's the same person?
Because original document of others cannot be kept with this person. Because others' documents, original document, migration certificate, he himself cannot keep others' document with
This is
him.
only a
Statement, I can understand, Lordship.
any other further document.
Further
So
document
he
71,
Chittaranjan shifted to village Milanpur. Where is Milanpur located? Dhubri.
not Milanpur. Prior to that, he was in Kasomari in Mongoldoi district, 71 voters list, Lordship.
Where is it? Page 71.
71 voters list in page 69, Lordship.
16 yes. So this is okay. Chittaranjan of Kasumari, he is there in 71. So this is a good document for you. So
This
now
is
how do you
Chittorgarh.
know Chittaranjan of Kasumari
Yes,
and
Lordship.
Chittaranjan of Milanpur are same?
Then they have shifted to Milanpur,
How will you prove it?
Geramari village.
You have to bring some more material, I believe.
Up one, down one voters list, otherwise I know.
Whatever it is, you apply your mind.
Yes, Lordship.
When
we
you
have
are applying
voters
your
list.
mind to give an explanation, you apply your mind to find out what possible material you may have. And bring it before us.
Lordship, if my friend brings the voters list
Okay, that
down.
will already, that
Yes.
order will be passed, but beyond that.
Beyond that, his school certificate, he is of
Milanpur.
Milanpur.
So only when you establish that Chittaranjan of Milanpur and Chittaranjan of Kasipur are same,
Yes,
Kasumari is
Lordship.
same, the school certificate would not have any value of its own.
Yes, Lordship.
Petitioner may produce any relevant material which may indicate that Chittaranjan Das of the voters list of 1971 of village Kasumari and Chittaranjan Das referred to be the father of Phukan Das of Milanpur are one and the same person. To facilitate the process, the election commission may also produce the upward and downward voters list of village Kasumari and village Milanpur in the context where there is a claim that shifting took place in
Yes,
the year,
Lordship.
just after 2 weeks.
And Lordship, in the other order also it's reflected, which is in page 84, where he was declared as an Indian. His, all these documents which he has relied.
Yeah, but that is not a decision. We allow you to rely on the same documents
Yes,
and then
Lordship.
show us that this document, now if the same documents cannot lead to a conclusion, or it is a little short of arriving at a conclusion,
Yes, Lordship.
that means the earlier forum did not give a decision. It gave a view. View and decision are two different.
Yes, Lordship. I'll try to get evidence of some other person.
So no need. If you claim that the earlier was a decision and those documents lead to a conclusion, show us those documents. We'll also look into it.
These are the documents only, migration.
We are not on this and that. You show us that those documents lead to a conclusion. Then it will be a decision.
Yes, Lordship. Appreciation is not there.
That's a difficulty. The law requires
Appreciation, proper appreciation. is
that
not-
res judicata between the same parties, and there must be a decision. And these are basically views that are found by one forum somewhere. It's his own personal view.
Opinion, yes.
After 2 weeks, so
Yes, Lordship. If elder sisters also adduce evidence, because elder sisters,
that will be very good. Then show that that
Yes,
person
Lordship.
is the elder sister.
yes, Lordship, that we can bring in. I'll get one more documents.
Think over, there must be something.
Yes, Lordship. Deep.
Item 15.
Yes.
Lordship, again. We don't want to take a time. On last occasion, one point arose.
Last occasion, one senior council came and made a submission that out of the same order, there are two criminal revisions in respect of two different accused persons. One accused person, by virtue of an order in a criminal revision, had got a favorable order. When the second revision came in respect of the second person, the learned single judge differed with that view and made a reference. In this circumstance, the senior council had made a submission that the petitioner of the other revision should be made a respondent in this one. We are asking a question under which provision of law? He was vehemently and aggressively stating that this is the law without referring to which is the law. So we framed this question.
Lordship, that much.
Tell us under which law,
Lordship, as
whenever there is a reference
Lordship,
on a difference being arrived at in respect to some other decision, in that reference proceeding, the other person should also be made a respondent. Where is that law?
that on previous occasion, learned senior council has submitted.
No, he has not submitted. He had only stated.
He stated,
Again, what Madam Ghosh is saying, there's a decision between difference between a decision and a view. Similarly, there is a difference between a submission and a statement. What was made is only stated.
Lordship, he was referring
to the question of natural justice,
Show us
natural justice and all. To that effect,
your Mr. Bhagavati.
Mr. Bhagavati,
Mr. Bhagavati, what is natural justice?
uh,
Only uttering high sounding words will not help in formulating a legal principle.
Lordship. Now,
What is natural justice?
to
From
that-
where does the concept of natural justice originally flow from?
to that
Yeah,
effect,
you have to
to
tell
that-
us.
to that effect, Lordship,
If you are still insisting that that man should be a respondent,
for that Lordship purpose, for that purpose, I just want to point out,
what do you want to point out?
Lordship, to that effect.
Mr. Bhagavati,
Lordship,
you are an experienced criminal lawyer. We believe so. Criminal proceedings are governed by CRPC.
Lordship,
It's not governed by administrative law. Natural justice is a principle of administrative law. Okay. Now we are in a criminal proceeding under the CRPC. First, tell us the interrelation between CRPC and natural justice. Number one. That's why I said always using a high sounding word may not lead to a legal principle. Right? Number two, suppose the revision court takes a view, the reference court, I mean, this one, reference court takes a view that will be different from what was taken by the learned single judge in the other civil revision. If that man is not made a respondent here, that judgment has attained finality in the respect of that person. He has a legal right flowing from a judgment of the court. Now, if you make him a respondent in your proceeding, and the conclusion arrived by the reference court is contrary to what was arrived at in the judgment in his favor, what will happen to his judgment? Have you ever thought about it? What will will happen?
I
Do you
also-
mean to
I
say
also want to learn from, one
you don't
discussion.
have to learn, you have to submit your own details. We are not on a law class here.
What I have understood here.
We are framing question only for our decision.
Lordship. So here in this.
So answer it, please. Suppose the reference court takes a view different from the one taken in that judgment. And that man is a party here. We implead him. What will be its implication of that contrary decision in the judgment which he is already holding in his favor and which has otherwise attained finality?
Now,
Not now. Please give an answer. We'll hear you.
for
Your now we'll hear you for any amount of argument you want to make. Tell us what will happen to that judgment.
that
A
will-
division bench will say that that proposition is as held by the learned single judge is incorrect. Proposition is otherwise. And he is holding a final judgment in his favor pertaining to the purportedly wrong principle of law. And he is a respondent in this proceeding. So the judgment rendered here will be binding on him. Because he is a respondent. What will happen to his judgment? Don't answer anything else for the time being.
Lordship,
Take the help of Mr. Makhan Phukan. He is a experienced PP. You can ask him.
Thanks for posing. Sir, I'm explaining the facts first, a bit.
Oh, wait till you, Mr. Phukan, you come here.
So. what-
Mr. Phukan, two accused persons, some order was passed, common order in respect of them regarding sanction or something, I believe.
Yes, that is
Whatever it is, forget
regarding
about the facts.
prosecution, requirement of sanction,
Ah.
prosecution section.
Some order was passed.
Cognizance order.
Please, no disturbing the middle. One of the accused person filed a revision before the High Court and got a favorable order where the revision court, the learned single judge, had arrived at a particular legal proposition. Other accused filed another revision. Other accused against the same order. The learned single judge in the revision court disagreed with the legal proposition of the learned single judge of the other revision and accordingly made a reference, and we are hearing the reference now. Learned single senior counsel who appeared the other day was vociferous and vehement in saying that the petitioner who's holding the other favorable judgment in his favor ought to be made a respondent here, urging upon the principle of natural justice. Natural justice is a very good concept of law. Firstly, from where does the natural concept justice flows from? Here we are dealing with CRPC. We are not going anywhere out of CRPC. Natural justice, we all understand, is a concept of administrative law. It's not of the criminal law under the CRPC. Firstly, whether it is applicable. Two, suppose it is applicable. We make the other petitioner a respondent in this proceeding, as urged upon by the petitioner. Now, our proposition of law that we will accept is contrary to what the learned single judge of that judgment, which was in favor of that person. And he is a respondent here. What will, and this will be a judgment of the division bench. What will happen to his judgment? Firstly, he is holding a judgment in his favor, maybe under a wrong proposition of law. He is forcefully made a respondent in this proceeding. The view of law taken is different. He is a respondent here. It will be binding on him also. What will be the legal position of that man? Whether he'll be bound by the final judgment in his favor on the wrong proposition of law, or he'll be bound by the other proposition of law that will be laid down in this proceeding, number one. Plus, mind you, whether it is a reference or whatever it is, this is a criminal revision.
First of all, the natural justice question doesn't come in the criminal procedure.
At least
Number one. Number two, the respondent.
it comes at times, but not in the manner as propounded under the administrative law. Certain circumstances, it may be there.
Then part, he is, no doubt, initially, the order was in his favor. The respondent party.
So now suppose we determine the law in the other way, and he is a respondent, he is bound by other division bench order. On one hand, he is having a judgment in his favor, final judgment, with a attained finality. Which of the two judgments will be now binding on him?
The division bench order is binding.
How?
Because
Mr. Fukan, this is where we are the difficulty is how. That means the final judgment, which is in his favor, would now be reviewed by the division bench. Can you review in criminal law? By implication, it will be reviewed. Can you review in a criminal law? No. This question is answered in the BSNL case by the Supreme Court, 2006, volume 1, I suppose. Check up and come back. And also with all these answers. And no forceful argument, only logical argument on the basis of law. Law cannot be imposed on the court. Law can only be substantiated before the court. This is why the question was framed. At least Mr. Bhagawati, you had the patience to answer, listen why we have framed the question. Other day, even the questions was also not shown. Have you understood?
I have understood.
Once we have analyzed it. And can it be done under the law?
Lordship, so far natural justice concept in criminal law.
Mr. Bhagavati, to give you the answer, maybe I can dictate it right now in my judgment. The implication will be, suppose we hold the legal proposition in a different manner, the state will have a right may accrue in favor of state to make an appeal against that judgment. That right state anyway it has to make an appeal. You cannot disturb his judgment by in a subsequent proceeding. Today, if you follow the Supreme Court, many an occasion you'll find questions are referred by deferring to an earlier judgment. Have we ever noticed where the petitioner of the earlier judgment been implemented in that reference case?
No.
One single instance you bring it before us. Why is it not done? Because it is inherently inconsistent with many other legal propositions. A final judgment benefit of a final judgment can be taken away only as per due procedure of law, not by forcing that man in another proceeding. So should I pass a judgment today on this issue, or you want to examine it?
In this point, Lordship, in this point.
Or else you withdraw your submission of making that man a respondent. We'll hear your revision as per law. Because this is a fabulous and unsustainable submission.
Lordship, what has happened in this case? So this is
Anything may have happened in this case. We'll have to follow the broad principles of law.
Lordship, to the effect of
See,
application of necessary
Today, if the reference court agrees with the learned single judge of the first revision,
justice.
it will be in your favor. If it is against, it will be against you. You will not get the benefit, other your co-accused will have the benefit. Then it will be open for the state to do whatever they want to do with it. You cannot forcefully bring that man in your proceeding and take away the judgment in his favor. That if I sink, you'll also sink with me. No, that is not available. Read well and come back. If you have contrary propositions of law, please point out. Not just for the purpose of raising an argument. It's a very, very serious legal issue you have raised. It has to be based on, because otherwise the entire concept will change, mind you. Tomorrow, the Supreme Court determines a referred question of law in a contrary manner. All those persons whose cases were earlier dismissed or the court went against, they will have a legal right to come back and make applications that make us also a party respondent in this legal proceeding. Everybody will come. Somebody who got an unfavorable order, say in the 1970s, he'll also come forward, that I also should be heard. Where the unfavorable man, favorable man has to be implemented, the unfavorable man also has to be implemented. Everyone, wherever that offending legal proposition was involved. Where did you stop? I think we spend enough time. You want adjournment or you want to argue?
We want to take some adjournment so that I can go through some.
Definitely, it's not a question of just urging upon. It's a
I'll back.
very serious legal issue.
Very serious.
Or maybe you are still right also. But that you are right would have to be substantiated. What is your view?
I have to also go through the same research on that point.
Sorry,
I also go through the same research on that point, my lord.
otherwise ultimately will be hit by that principle that there cannot be a review in criminal law. Moment you bring back the other person who is having a final judgment, you are subjecting him to a implied review of his judgment. You cannot do it. He has his own legal right under the law. If the state goes in appeal, the higher court set aside and again sends it back, that as a reference court is hearing this issue, let it be heard together. That is another matter. Then we'll be hearing his revision, not as a respondent here in your revision. No other way out. That's why I said in the opening remark that natural justice is a very fanciful concept. It's having a wide application. But everything is not natural justice. When you want. Mr. B. Bhagavati. B. Bhagavati, learned counsel appearing for the petitioner in today's hearing seeks for an adjournment to examine the proposition which was earlier, the question which was earlier framed
26-4.
by the order of 26/4/2023. When do you want? Next
2
week.
weeks, Lordship, 2 weeks then.
2 weeks. 2 days is also not required. Next week, let's come prepare. Weekend, you prepare yourself.
18th.
Mr. Puran, you also helping if you get something.
Item 21.
Please, the lordship. Lordship, the petitioner's father's name appeared in the voter list of 1966. The lordship from village Samdhara, page 1819, your lordship.
It's 16.
18, 19. Ohed Ali, Ohed Ali,
Samdhara.
lordship,
Ohed Ali is the father.
lordship.
And which document will show is the father?
Lordship.
Which
Lordship,
document will show
I
is
have
the
a
father?
school transfer certificate. I have annexed
Page
it,
number
page 22,
20.
22.
Headmaster examined.
Lordship, that has not been examined.
And village is also different.
Village, your lordship,
It is, the petitioner relies on the voters list of 1966 of village Samdhara, which contains the name of Ohed Ali, son of Isab at serial 181,
lordship,
and claims that Ohed Ali of the 1966 voters list is her father. To substantiate the said claim, reference is made to the transfer certificate issued by the headmaster of Borguli ME Madrasa, which contains the information that Morjina Begum is the daughter of late Wahed Ali of village Bhurbandha. Firstly, it is noticed that the 1966 voters list is in respect of village Samdhora, whereas the transfer certificate relied upon to establish that Wahed Ali is the father of Morjina Begum is in respect of village Bhurbandha. Petitioner may produce any relevant material which may show that late Wahed Ali of Bhurbandha, as referred in the transfer certificate, and Ohed Ali of the voters list of 1966 of village Samdhara are one and the same person. List after a week.
Your Lordship, there was another document, Your Lordship, where I have annexed a birth certificate, Your Lordship. I have filed an additional affidavit, Your Lordship.
Birth certificate also.
And Your Lordship, I have,
Which page is the birth certificate?
Your Lordship, additional affidavit,
No, find out the page, running page number.
page number 4 is the delayed permission, 5 is the birth certificate.
Running page number.
Your Lordship, earlier, Your Lordship, it used to be in additional.
Running page 9. Extra file. Running page. Report that is again. Page number 1. Page next to the last page of the original. Raised it to list again along with the running page number of the additional affidavit of the petitioner. This next item.
Item 22.
A2 proceeding or running page again. No, notum to the when the new affidavit is enclosed, at that stage they must make the photo to enpa colonization given alagable. Yes, Mr. Phugon.
May it please, Your Honor. Here, my lord, the petitioner is a my lord, the BSF serving as a BSF security, my lord, the BSF force, my lord, as a constable. Now, my lord, he filed these petitions, my lord, for challenging the my lord order dated 3/10 of 2012, where he was sentenced, my lord, for life imprisonment, and he is dismissing from service.
Yes, there was an earlier order of 2/2/2023 records. There is also a personal presence. Custodian will remain personally present. Where is he? It order to put you.
Personal present.
Madam Sharma, we are not very impressed with the expression that is there. What is that is there is a judicial order which has its own sanctity. Please read it. Then you should file an application for recalling that order.
After Lordship, he was present, Lordship, but today, yeah, as it is not.
Whatever it is, the order is not recalled.
This person is not here, but other person.
Doesn't matter. Custodian the record. We are not on this person, that person. Whoever is the custodian of the record. Ask your officers to give at least some sanctity to the court orders. Otherwise, we are not going to entertain you. Doesn't matter. Doesn't matter. The remedy is to file an application if you want it recalled. Or at least the minimum courtesy of an oral prayer. Not to be responded with, that is there. That is, let the judicial order remain there it is. I will go as per my own wish. We refuse to accept it.
Even I'm wrong, I thought that here perhaps.
Doesn't matter. Your thinking will not change the judicial order. Or you file an application to recall it. File an application, will record it. But judicial orders can't be treated in this manner. Will not allow it to happen.
I'm not praying for recalling, I'm only praying for another date, because today he has some personal difficulty, he has to come from Nagar and he could not reach today.
Doesn't matter. Why your officers feel that they are above the law? It cannot be. You may be a member of a force. That doesn't mean the law is not applicable to you. We can't appreciate this behavior. You may argue that the relevance of remaining presence is, as on today, is not there anymore. But as long as the judicial order remains, you are bound by it. This may be a very good cause to recall that order. But it cannot be a reason that it may be there. That is there. So tomorrow, every litigant, every officer government will start taking a stand. That is there. Let it remain. We are unhappy with that expression. That is there.
Or
Sorry.
I will file an application, or lordship will kindly give you one, at least, today he is
No,
not
no, we
ready.
don't want to see the face of a person. We just only on the sanctity of judicial orders. We are not interested to see somebody before us.
I'll file an application.
Wait. But your expression that is there.
Sorry,
Please,
lordship,
please don't.
I don't want to say that.
But you said it. I think you said it. It's recorded, this proceeding. We can rewind the proceeding and show you that it was stated. Yes, Mr. Pugam.
My lord.
File an application recalling that one. Yes, you continue. What is your case?
My lord, here the petitioner filed this criminal, my lord, the writ petitions
We
criminal.
want back our records. This is a criminal writ petition.
My lord, yes.
So what happened?
My lord, he killed 2 persons, my lord. And
A
he was
BSF man, he
My
killed
lord, yes.
2 persons.
2 persons and
And
also,
what was held against him? Court martial.
yes, my lord. That point was raised earlier occasions, my lord, whether the writ has a jurisdictions or not, my lord.
Writ petition, we have jurisdiction.
Oh.
Who raised the issue?
My lord, dear lordship, my lord, on that they said that but whether 226 will be applicable or not in court martial cases. Last occasions, your lordships.
If not, then what will be applicable?
My lord, jurisdiction, there is a jurisdiction of 226, my lord, to proceed the case. My lord.
No. Once a person kills 2 persons, that means section 302 of the IPC
My lord,
is
yes.
applicable.
My lord,
Normally for proceeding in respect of 302 IPC, we have the CRPC.
my lord,
CRPC in different layers, the provisions for appeals are there.
my lord,
The man may have killed, that may be the allegation.
my lord.
But that person is also entitled to a judicial scrutiny as to whether the conclusion arrived at it is a case of 302 is right or wrong.
My lord, yes. And moreover, my lord, the one more my lord order is there. Imprisonment for life and to dismiss from service also there.
No, that
There is a
separate.
DP, my lord,
That,
discipline proceedings.
that is a separate one. We'll separate the 2 issues.
My lord.
It will seal the seizure to assign to DB2. Itu transfer ya, আমার presence report. To 302, I think. Registry matters in joint register. Note that single bench chief editor is to joint register. Mr. Phukon,
My lord,
in regular course, any writ petition against the order in a court martial is before single bench, I believe. It's a bench 4 matter, I think.
my lord,
Suppose minus the 302. Had
Then
it
in the
been
case of single bench.
challenging a court martial, it is a regular bench 4
my
matter.
lord, yes.
Here, even 302 is included. And the law says that even in respect of 302, court martial army authorities have the jurisdiction,
My lord.
or they don't have the jurisdiction.
They have the jurisdiction. My section
Where-
80 of the BSF.
That judgment.
Judgment is not there, my lord. Section 80 of the BSF Act, they have choice, my lord.
Here is some BSF Act also.
BSF Act, my lord, section 80.
Is there any, did the Supreme Court ever gone into this question?
My lord,
Has the Supreme Court gone into this question? That if there is a component of 302 IPC, then also it will be that BSF Act court martial, which is the provision section
section 80, your lord.
80.
80. Choice between criminal code and security force code, my lord. When a criminal code and a security force code have its jurisdictions in respect of an offense, it shall be in the discretions of the Director General or the Inspector General or the Deputy Inspector
And
General.
where is the provision for security force court?
Security force code, my lord.
Hmm.
Uh, 46, section 46,
Section 46.
civil offense. Subject to the provision of section 47, any person
There
subject.
is shall be deemed to be guilty of an and is civil offense defined?
Civil offense definition, my lord. Means an offense which is tribal by a criminal code. Definition says, my lord.
Civil offense means
Civil offense means D, my lord.
tribal by a criminal code.
My lord, yes.
Where is it? Which section?
Section 2D, my lord.
D. And after this choice, what will happen?
My lord.
After this choice is made, suppose
My lord,
choice is
yes.
made for security
My
force
lord.
court, then what happens?
Thereafter, my lord, after the it was sent to the, my lord, the security force court. Then they have, my lord, they call for the list of documents and the list of witnesses.
No, we are Indian Court of Ordinary Criminal Justice. Indian Court.
As like trial, my lord, they have
Just
continued
when
as-
you come on in respect of a civil offense. Criminal court means the court of ordinary criminal justice in any part of India. Which is triable by criminal court.
And after convening the General Security Force Court, they have framing a charge.
No, we are not exactly on that. (302) trial is a specialized trial. 302, in a case of 302, it's a specialized trial
My lord,
to be conducted only by the Court of Sessions.
my lord,
Even the magistrate is excluded.
my lord.
Why? Because you need a little higher acumen in judicial adjudications, and you are well versed with that criminal law.
My lord,
Okay, so it will be tried by a Court of Sessions. Now, by virtue of this provision, if an officer of a battalion is holding the court martial, is that man judicially trained to try a case of serious nature of 302? And 302 is not an easy law.
my lord, yes.
There are many variations, deviations, circumstantial aspects, many things are there.
Lord, sir.
So why is it tribal by a session? There's a reason behind it. Otherwise, anybody could have tried a 302.
My lord, yes. But because of these
Because the
sections,
session judge, what happens by virtue of his experience in the judicial stream, he acquires a particular judicial acumen where the law deems that he is fit enough to judge a 302 case.
my lord,
Now, if you give it to the commandant of a battalion, that same would
Lord, sir. Because of these sections, my lord,
understand. So,
and now,
had it been a criminal offense of, say, ordinary nature, say he had stolen one mobile phone of his
Yes,
colleague or this or that, we understand. Yeah, let the commandant keep on taking his decision. Because there is not much complication in that, only factual determination whether the mobile phone is of the other man
my lord,
and whether it is found in your possession or not. These are the only two factual determination.
Lord, sir.
But 302 is
A very heinous offense.
it's a huge concept.
My lord. And for last 10 years, he is behind the bar, my lord, this present petitioner.
So who can, your dismissal also, we are not on that.
My lord, yes.
If the commandant feels this kind of a man of this behavior, that he had killed 2 persons is not suitable, we will look it from a different point of view. But to convict under 302, nearly every killing may not be 302.
That's why I'm coming here, my lord, is converted to 304 part 1. My lord, it is not an intentional, and he
No,
was provoked.
understand, no, we can do it, but what will you do? We'll exercise jurisdiction, judicial review
My lord,
of that commanding officer in the court martial proceeding, and
My
the
lord.
force court proceeding.
otherwise I have.
So
no
we are
any-
exercising that jurisdiction.
My lord, otherwise I have no any way to go.
But had it been a regular criminal trial, A criminal appellate court would have been looking into that
My
question.
lord. Initially, it was come before the criminal court, my lord. And later on, my lord, again, it was listed before the, my lord. Initially, it was before the single bench.
I know.
Then again, it was sent to the, my lord, the criminal bench, the division criminal bench. And again, my lord, sent to the, my lord, this bench.
Now, Chief Justice has given the jurisdiction, will hear it. And that is also requirement is a division bench, this is also a division bench. From that point of view, also not difficulty. Chief Justice is entrusted to this bench.
My
He has
lord.
no difficulty.
My lord,
He is the master of roster.
my lord,
Plus, requirement of hearing a criminal appeal is by division bench, that is also
My lord,
satisfied.
yes.
There's a division bench
my lord,
hearing.
yes.
It may not be technically
Lordship,
taking up the regular criminal
my lord,
appeals,
correct.
but that is there. But what we are asking is, we'll be hearing basically what that commanding officer had done. And we'll exercise only jurisdiction of judicial review.
My lord.
Now, who will deal with that specialized criminal law? You have the records. Where did he exercise that discretion? Let us just find out. We'll come back at 2 o'clock.
Crossing.
Under that section, which section 80, it says that he'll exercise a discretion.
Hmm.
But now again, I don't want to set aside and send it back
My lord, yes.
after 10 years now.
And rule, my lord,
Hmm.
rule 41 is also there, my lord.
Choice between criminal and security in the discretion of the Director General. Where is that discretion? He exercised. You find it or we'll come back. And you also think over, merely because this man is serving in the BSF, he is subjected to a criminal trial of section 302 IPC by a person who may not be competent to conduct a trial.
Army and lordship here is, on the last level and lordship.
Is it a case of 302? Violating provisions of Army Act constituting criminal offense, we understand.
No, it's not.
We are specially on 302. Because 302, if you find out, on that section itself, you may have 2 volumes of big books also decided by the Supreme Court. If it requires that amount of judicial decisions to arrive at the concept of what is 302, is the commanding officer competent to, or does he have the knowledge of those laws to decide whether it's a 302 or not?
The sentence was given by, my lord, the persons who have signed, my lord, the Deputy Inspector General.
Whatever it is, maybe deputy, maybe the Director General also, is he competent?
Lordship.
Or is he aware of those volumes and volumes of law that had been laid down by the Supreme Court? Otherwise, his decision, if he doesn't know the law, his decision will be incorrect.
And more interesting, my lord, the confessional statement which was taken, which was not as per law, my lord, 162.
That is again, it's a question of law. We'll hear you on this. No, যদি proper মাধ্যমে যদি trial করে না, even সেটা his legal right will be affected in not getting discretion for and even if he exercise discretion, is he a man competent? Or is he aware of the requirements of the law? What he will decide? Had the law been simple, any one person killing another person is 302. We understand. The man will have it. All that he'll have to have material before you is that this man had caused death to another man. The difficulty is law is much beyond that. Come to the mic.
The act or something else.
First, you find out if this question was ever gone by the Supreme Court and if whether there is an approval. Then even this regular authorities can also decide at 302. If not, we'll have to, because this is 226 before us. It's not a criminal appeal. We cannot adopt the principles of criminal appeal and just say that this is an incorrect conviction. Then what will we decide? Whether he had followed the proper procedure or not? He definitely must have followed.
Yes, that is. possible.
Some witnesses are there. Somebody is saying this is that framing or charge. Yes, we have done it. He have followed it. Should this man be condemned? Suppose it's not a case of 302. Khokon is trying to urge that bring it down to 304. How will we do it? We'll be basically substituting ourselves as a criminal appellate court and appreciate the criminal law. Yes. Madam Sharma, you asked Mr. Didi Chaudhary also to remain present. It appears to be a little serious question. You also remain present. In the meantime, find out whether there is a definite proposition. Just yes, it can be done. If it can be done, we proceed by following that decision. If it cannot be done, we'll have to possibly go into that question also. And mind you, for 302, law cannot be different between a BSF person and a general citizen. For the discipline, etc., everything it may be, but not for these serious criminal offenses. There cannot be difference. Tomorrow? Tomorrow.
Tomorrow, I have to provide these documents to Mr. Argadev Chaudhary and he has to.
This is a legal proposition, just ask him. You don't have to provide any document.
They're on Thursday, Lordship. Tomorrow,
Why not tomorrow?
tomorrow already some cases.
You
so
are very busy tomorrow.
Not very busy, but
No, we don't like to keep matters pending and waiting like that. We have started the hearing, at least we should go ahead. Tomorrow, if you need time, we'll give you tomorrow also. And let it be tomorrow to start with. So we'll also look into this question. কি করিব তো You want on Thursday? Okay, on Thursday, if you want on Thursday. Firstly, we have to understand, setting in this 226 vote, what we will be doing and what we will be looking at. If you say we are strictly from the point of view of a judicial review, the basic concept of judicial review, then we'll be only looking into whether any procedure requirement was followed or not. If you want to look at from the point of view whether this conviction under 302 is a right conviction or not, we will be substituting ourselves into a criminal court and then look it from the regular point of view. And before that, we have to know whether whoever had done this thing, whether he is under the law competent to do it or not. List for further hearing also.
Much of.
In parts.
Much of them.
One aspect, Mr. Goswami,
my lord.
we also refer to the Forest Conservation Act 1980.
Yes, sir.
Sorry, huh? Forest Conservation Act, they call it. Forest Conservation Act. Okay, so- If you read section 2,
My lord.
there it আৰু সেই শিডিউল ট্ৰাইব এণ্ড ট্ৰেডিশ্যনেল ফৰেষ্ট বিলাক নাই দুইখন লাগে এইখন দি দিব বাৰু এইখন দি দিব এইখন দুইটাতে আছে অ নাই এইখন বড়ো এইখন এট্ৰচিটিজ এক্ট নট দিছ ওয়ান দ্যাট নট If you come to section 2,
My lord.
notwithstanding anything contained in any other law, so non-obstant clause,
My lord.
for example, no state government
Or other authority.
or other authority shall make, except with prior approval and any order directing, read Roman 2, that any forest land or any portion
Portion
thereof may be used for non-forest purpose.
My lord.
So this is a prospective provision. This is a provision which is prospective in nature from the
True.
date this
True,
Act of 1890 came into force.
So for the retrospectivity, my lord, Forest Rights Act comes in, my lord. Other.
No, I am coming to that
My
one by
lord.
one. So, as this is a right given in 1974, So whatever is given will not be impacted by this Forest Conservation Act. Means from 1980, they could not have done it. But whatever is already done,
In,
that will not be impacted.
in this case, my lord, there was a proposal to allot, my lord. It was never concluded, my lord. So
It was
now,
allotted. The persons are staying there from 75. How can you say it is not allotted?
not allotted, my lord.
What do you mean by allotment?
My lord, the proposal was.
Mr. Goswami, we are trying to distinguish between a formal piece of paper where it say that I have allotted to you,
My lord,
and there is a,
physical.
you call it proposal or whatever it is, but you act upon it, put the parcels in place now for the last 40 years. So how can you say that it is not allotted? That will be a very hyper-technical approach to say that you are not allotted, but for all purpose, they are allotted because they are already inside. So whatever rights were given to them in 1975, they are not impacted by the Act of 1980. From 1980
That way-
onwards,
that
you
way
could
it is
not have
perfect.
done it. So this is one aspect of the matter. So Act of 1980 possibly will not
May
come
not
to
have.
much of an aid from that point of view. And Forest Village, if you come to this Scheduled Tribe and Traditional Dwellers Act,
My lord. Section 2, subsection M, my lord.
no, P. M is,
Not M, my lord, O, my lord, O.
no,
Other
not O, I want P.
village means,
Village means tree, forest villages.
yes, my lord.
So although we came to some conclusion that Forest Regulation 1891 does not provide for any forest village, but
Under this act, there is a.
this
concept.
act, that concept has been brought in.
Yes, my lord.
Okay. So something of like
Forest-
forest village is also
Ex-
there,
exists.
although the regulation on its own may not recognize it.
Exactly.
Now, village means
Forest village,
forest village, whether notified as village or not. Forest village, a village means a village referred in so and so, these things, and also forest village, all habitational settlements and unsurveyed villages, whether notified or not.
yes.
Now, except for this definition of village, there is no reference to any forest village in the entire this act also.
Exactly.
Only thing, the definition contains the expression forest village. Village also means.
Exactly.
I have not noticed the word forest village in this 2006 Act, other than in the definition at 2T.
Yes, ma'am.
Just take a quick glance if you notice somewhere.
Yes,
Possibly,
it is only there, my lord.
possibly it is not there. So if it is not there, even if the expression is do appear in the definition of a village,
My lord.
but if the regulation does not provide for it, possibly we'll have to read this word also that way, merely because
For the purpose of this case, this one,
merely because the word forest village do appear here, that will ipso facto not mean that this 1975 also created a forest village
exactly.
by virtue of rule 1 and 2 of that establishment rule.
Right.
Possibly it cannot be interpreted that way, merely because this word exists in some other act.
Exactly, ma'am.
And moreover, if you see the beginning line of section 2, it begins with in this act, unless context otherwise requires.
Exactly.
So
There may be
firstly,
other contexts also.
firstly in this act, and secondly, unless the context otherwise requires. But if the context otherwise requires, meaning thereby
It is exclusive basically.
in regulation of 1891, it is not there, then it is possibly it is not there. You cannot create something which is not there.
Exactly. And
But
my-
again, if you want to take advantage of this expression village forest, then it has to be under this act. Under this act, it is open only to scheduled tribes
and
who are traditionally residing in the forest and other traditional forest dwellers. Both of them are well-defined concept.
exactly. The petitioner
If
doesn't
these
come under.
petitioners come within the definition, maybe even entirely. If you don't come, even this act is not
Yes,
applicable.
but petitioners don't come, my lord, because
They possibly don't come.
Because
Why?
they are
examine
not
it.
scheduled caste, my lord. At best, they can claim other traditional forest dwellers. For that definition, O takes care of, my lord.
Oh, I don't think they satisfy the requirement of O.
Doesn't satisfy, my lord. Other traditional forest dweller means any member or community who has for at least.
So
three
they
gen-
have given a cutoff also, December
Yes,
two
it
thousand
is
five.
retrospective, my lord.
So
Prior to 2015.
at least 3 generations
Prior to 13/12/2005.
primarily resided and you depend on forest and land and for bona fide livelihood.
Exactly. Then, my lord,
Number of conditions are not satisfied.
Explanation, my lord.
They're not there for 3
and
generations.
my lord, may kindly see the explanation below, my lord. For the purpose of this clause, generation means a period comprising 25 years. So minimum 75 years prior to 2005. It goes back to, my lord, 2019 or 30. Their
1930.
claim is for 1970s.
We are residing prior to that in the forest. Our statement is the prior to that.
Mr. Borbhoya, your statement will not create a fact. You cannot reside prior to it because prior to it, Rongriyang tribal people were residing there.
And
They were evicted.
and
And then these people were brought in. So your statement that you were residing prior is unacceptable.
Really, document said in that area, young people are living. And that land, we have not been allotted. We have been allotted in the existing forest village.
Then you have to revive Mr. M.A. Islam, who had you passed that order. Ask him. You have to bring him back. That conservator, Mr. M.A. Islam, who had passed the order, you have to bring him back. Then these are the language of 1974 letter is very clear. That Rongriyang people are evicted. Now to ensure that they do not re-encroach, I hereby bring in 60 different people and place them in place of the Rongriyang people.
I think, my lord, these Riyangs are, my lord, Sakmas of Tripura.
Hmm.
Tripura Sakmas are called Riyang, I think.
Rongriyang or Chakmas of Tripura.
And Sakma, my lord, for the purpose of Karbi Anglong and NC Hills are recognized scheduled tribe in Assam. ma'am.
Where is this one
It is
located?
in Borak Valley, my lord.
Borak Valley. Anyway, that is not the issue before us. So Forest Conservation Act will not be of much aid. And only difficulty is this forest village appearing in the definition of 2P. And that too in the context
Of
otherwise.
2005 Act. It is in the context of that act, my lord, and that act itself excludes the petitioner.
And plus that act is not applicable for them and neither there is any claim.
Exactly.
Are we making any claim under the Scheduled Caste Act?
We are not claiming.
We are,
We paid.
Mr. Borbhoya, we are dismissing your writ petition.
Allotted. Authority
Yes,
allotted.
we are dismissing your writ petition. We examined from every aspect, but could not locate any legal right.
But as per establishment, for the 6 months notice may be given, but that may be important.
The matter already remained pending for 6 months. That itself is the notice.
When the authority.
there is an interim
will
protection also.
ask lordship, 6 months notice as per clause 14 of the establishment.
That you ask, tell them to give you notice of 6 months. We are not asked.
And my last submission is that even lordship of commission with department. May approach the department already issued notice to us. For verification of the records, whether they are the. legal
What,
heirs of the original
the notice under what provision?
And they have issued notice, lordship, newspaper notice. lordship.
Notice under what provision of law?
So, earlier, the fourth occasion lordship, they inquired the matter, it was not completed, and subsequently another notice was issued in the newspaper caption. And we
Very
have
well.
asked to produce the documents, whether we are the legal heirs of the original LOT, that may be verified.
We are not concerned with the expression legal heirs.
Original.
You have no right to remain there. Whether you are a legal heir or you are the original person, you have no legal right.
We have been deciding last 46 years. lordship. Yeah.
Still, you don't have a right. Duration does not create any right. And forest has been residing there since thousands of years. What we have destroying. So the forest has a better legal right. Those trees standing there have a better legal right than your 40 years.
Oh, we are not claiming to the 6 regular.
So don't you think,
But we are protecting the forest.
Mr. Protecting. So are you also protecting the rice that you buy every day to cook your rice meal? Are you protecting it or you are consuming it? You are consuming. Very well. We have taken a call. They have no right to do that. Even your conservator forest did not have the right to do it. But you make an application, they will consider them under the regular land policy. Definitely. That right you will have. We recognize that. Under land policy, give them some land because rightly or wrongly, one of your officers have given him some land. Only thing is that location where the land is given is a prohibited area. If you want to give him land, give him in a better place where legally it can be given. Make application, we'll pass a order that they consider it within 3 months. Mr. Boruhia, we had already put you a question. When there is a legal right vis-a-vis of the,
Like the article 21 in this.
then you come out today itself. Pass a direction to vacate today itself, right now.
I leave it here.
If you're insisting that one, that I have a right to stay inside the forest and destroy the forest, then our response is come out today itself.
My humble submission.
They should not, that should be a little more responsive. See the state of the environment, see the state of what is happening everywhere. In places like Southern Europe, the roads are melting.
Exactly. In London, my lord, UK, last year, my lord, summer temperature rose up to 40 degrees.
40 degrees. Today you see in Tripura what is happening. Unbearably hot today, if you read the news. All because of these people. So where is the legal right between those human beings in general and 60 people who want to enjoy the forest? When you compare the two legal rights, whose right is better?
This some kind lordship in the since we
Tell
left
them. I want you.
lordship that may-
My lord, record that I will instruct the DFO to, if necessary, issue a notice for eviction. my lord.
Notice.
notice.
If they want to evict, my lord, it will be preceded by a notice, my lord. But because if any.
What notice under which provision? There is no provision for notice in a
Exactly.
forest.
Only in wildlife sanctuaries notices are required. Otherwise, it's not required.
In forest land, there is no provision for notice. You should not enter the forest.
Establishment for establishment use lordship, no, notice in. That's specific word lordship.
Well, throughout the proceedings, my lord, on the very first day, I took a given undertaking that my lord will not evict
Yes.
till my lord decides, my lord. Any further interim order at the stage of conclusion of proceedings, my lord, they will,
We are not inclined to pass any interim order.
14 said the particular man in occupation of land allotted to the forest village by giving 6 month notice.
See, we have already given our observation that this rule is in conflict with the 81 regulation. We have already arrived at that conclusion that you cannot rely on this rule anymore. And this is a mischievous and frivolous rule. Somebody had made it. This
was a-
rule is made under section 72E, 74 and 75. What is 72E? Additional power to frame rules to carry out the provision of the regulation. If the regulation does not provide for forest village and settling people inside the forest, you cannot frame a rule to put somebody inside forest. This is number one. Section 74 is whosoever is inside or outside the forest has a duty to inform if there is any forest offense or there is any fire. That does not empower them to frame rule to put somebody inside the forest. 75 is if you have any due to the forest department that can be recovered as area in land revenue. So where is the power of the to frame rule to allow 60 people to stay inside the forest?
Well, that was a rule framed by colonial planters, my lord, to suit their cause, my lord, of exploration.
You withdraw that rule immediately.
Yes, ma'am. I will instruct.
Well, that's a no power is there to
No
frame
power.
that kind of a rule. Okay, we'll sign the order. Only thing in the end we'll provide,
They will make an application to the DC under the
but
land.
however claim that they are landless people as depicted in the letter, they may submit application for allotment of land under the appropriate land policy government. In the event it is done, be taken up as per law by following the relevant provision.
Right.
As we'll add one more line, as the petitioners will now have to vacate the forest land. Such application may be considered within a period of 3 months from the date of receipt of the application.
Obliged.
Otherwise, there's we are discussing. So, Borja, I think as a counsel for the petitioner, you are arguing, but in your mind, you must be agreeing with us only. Everything, whole world will be doomed, mind you. These activities are allowed. And what is the forest department doing?
But
That's-
nowadays, my lord, we are going for large scale eviction, my lord. Even lambding we have done, my lord.
But where are the forests?
Well, it is an admitted position, well, there are encroachment and there are,
No,
Yeah,
no,
the
but
forest.
where are the forests?
if we can remove, my lord, the encroachment, forest will necessarily come up, my lord.
How much of afforestation was done for the last 5 years?
That data, my lord.
Was something done?
There are projects, my lord.
The projects are there. Project and providing in paper are same thing. In ground reality, how many new trees have come up? Which area afforestation had taken place in Assam?
My lord, in Sonitpur, there is a Friends Bank project, my lord. They have sponsored the project, my lord. Sonitpur we have done.
No, except for that person, Jadhav Pegu, I think,
My lord.
Jadhav Payeng.
Jadhav Pai.
Was any further tree being afforested had taken place anywhere?
Yes, my lord.
Where?
In the throughout the state, my lord.
Where? No,
I'm not saying it is up to the satisfaction, my lord, but.
No, in
attempts
which
are being
place?
made, my lord.
We would like to go and see. We'd like to visit some forests where afforestation had taken place in the last 5 years. So which place? Which place to go now? Suppose a citizen now wants to take a look at the places where afforestation has taken place. Where should he go?
There are areas, my lord, I can.
Not
forget it.
areas. We want to know the areas only. Where should they go?
There are national parks, my lord, reserved for forest, wildlife.
No, I said, I'm asking
Afforestation.
only afforestation. Where previously the forest was removed and this is what we have done to bring it back. There are some area where the citizens can go and enjoy that afforested area. Enjoy the forest there.
There are areas, my lord, may not be up to the satisfaction.
Not that, which one?
Praise that. Right now, my lord, I'm not in a position.
Ask your officers that court is asking a question. That if the citizens would like to desire and to enjoy the forest or see the forest where afforestation had taken place in the last year, where should they go?
Look, one environmentalist once told me, my lord, that the topography of Assam is such, my lord, if we keep certain area free from encroachment, my lord, trees automatically grow up, my lord.
But that is the
That is not
courtesy of the
forestation.
automatic growing the tree, but
That is not
afforestation.
That is not forestation.
Hmm. And Mr. Goswami, if you happen to pass by the highways,
Yes, my lord.
we pass through several forest areas. Nowadays, the situation is such that between the trees, you can see some vacant land behind. Whereas it ought to have been a continuous forest.
Yes, my lord.
That means to show that people that the forest exists, about 100 meters or so from the highway, you will don't allow trees to be cut.
Yes.
But beyond that,
True, my lord.
nothing is there.
Balipara.
And I don't think God created a forest in this way that it will be exist only with 200 meters of either side of the highway. And
That is
beyond
what
that,
we humans have done.
there are no trees. I don't think God created forest in that manner.
That is we humans have done, my lord.
Please do something.
We are trying, my lord.
Dismissing one petition is not just enough. What to be done? We may put you this question somewhere sometimes, or maybe Somoto take it up also on a given day.
There is a PL, Somoto taken up.
Let it be taken up.
There, my lord, the issue is that in the interstate disputed boundary, in the name of political dispute about a boundary, my lord, both
Oh,
sides are.
that
encroaching.
PIL take up its own issue. We are on where afforestation is done.
Yes,
We-
precisely that is the PL, my lord. Ahom Bosok, that PL.
Let it
petition.
remain. Now, we have to take it up again. There cannot be, in these issues, there, nothing that multiplicity of
True.
proceeding
There
is
no
not.
technical
permissible.
will come. my lord.
Mr. Goswami,
My lord.
we'd like to appoint you as an ambassador of the people to ensure that these things are happening. And from time to time, we'll be asking you.
I would love to, my lord.
Mhm.
I would love to, my lord. It would be an honor for me.
Please do it. Save everybody. You, by holding your position,
Right.
you take it, you so much to take it up on your own. Keep on asking. And we'll keep you asking from time to time whenever we
My
come
lord.
across.
My lord.
Hmm. Situation is very bad.
Very bad.
It's very bad. It's almost getting, that critical line is almost over.
Almost.
Or you can see it's over itself.
Too much.
And now also you don't act. The future generation will not forgive you, mind you.
Very true. my lord.
Mhm. And it won't be very difficult. And wherever afforestation is there, the eucalyptus trees are planted. Because it does not need any further care to be done. You just put one sampling. But eucalyptus, the damage it is causing, you know. It consumes the quota of water of all the nearby trees. It's like a parasite kind of a thing, this eucalyptus. And wherever you find something is there, only eucalyptus trees, nothing else. Not the actual trees.
Actually, there should be different types of plants planted. What,
Eucalyptus, you make your cultivation, no one is stopping you. But that should not be inside the actual areas because they consume all the nutrients and water of the other trees which would have existed there. It will kill the other tree.
yes, and for the purpose of Assam malad, it has no utility. Ma'am.
So will you act as an ambassador?
I will make an endeavor, madam,
Mhm.
to the best possible. I will do.
Take it as a personal cause and see. And you encourage your forest officers to do the needful. Let us all awake to the problem instead of ignoring it or sleeping over it.
I will do, madam. I will try, madam, definitely.
Is it okay? You pass this order, you apply for some other under the land policy. Thank you.
Okay.